We're now live.
Good morning,
Okay.
ladies and gentlemen. My name is Pat Pirtle. I'm one of the justices on the Seventh Court of Appeal. On this panel today with me is Justice Judy Parker. Wave there, Judy. And also Justice Larry Doss. The matter before the court today is cause number 07-19-00362 Bertha, Arce, individually and as representatives of others similarly situated versus American National Insurance Company. Mr. Tyser, are you ready today on behalf of the appellant?
I am, Your Honor.
And Ms. Olalde, are you ready on behalf of the appellee?
Yes, Your Honor.
Counsel, both sides will be given 20 minutes for their primary remarks, and then the appellant will have an additional 5 minutes. The timer there in the corner of your screen should help you keep track of that. With that, then we will proceed. Bobby, I forgot to give you your introduction. Bobby Ramirez is our staff attorney there in the corner of the court, in the corner of the screen, and he's our bailiff to make sure y'all don't act up today. So, Mr. Tyser, if you would like to proceed, you may have the podium.
Thank you, Your Honor. Good morning. Would you like me to stand, or is it okay to sit?
Whatever's comfortable with you, sir.
Thank you very much, Your Honor. Your Honor, this case presents the central issue of whether the 2005 recodification of the Texas Insurance Code, and specifically Chapter 705, and more specifically 705051, changed over 100 years of settled law for the elements of rescission of an insurance policy, in this case, a life insurance policy. In this case, Annex, I'm going to call them Annex as per their acronym, if the court doesn't mind, rests on the flawed premise and what I would call a straw man assertion that Section 705051 provides the exclusive basis for rescission of an insurance policy, here a life insurance policy, because the recodification of in 2005 and of Chapter 705. And specifically, they argue because 705051 does not mention intent to deceive, it is therefore no longer required to be proved to obtain rescission of an insurance policy based on the defense of misrepresentation. I say this is a flawed premises because the prior statute, Article 2118, which is the prior statute, there's no substantive change between 2118 and 705051. That statute never included any intent to deceive, nor was it the exclusive basis for rescission of an insurance policy, particularly a life insurance policy, based on the defense or grounds of misrepresentation. The remedy, the test for rescission, has been and remains the common law test set out in Mays and Shelton. It's a 5-part test, and part of that 5-part test is the intent to deceive. That test has been reaffirmed as recently as in Medicus versus Todd, and even the cases that the ANIC relies on, Parker and Lamberos, apply the common law test, although they arbitrarily take out this intent to deceive element, which we'll explore shortly. The Texas legislature, as ANIC points out in this brief and in the summary judgment, as do we, was clearly aware of the common law test, the Shelton test, the Mays test, 100 years of law, when they recodified in 2005. They made no changes to that law. They made no, they did not abrogate the common law remedy. All they did was recodify the statutes in plainer English, so to speak, and renumbered them in another part of the insurance code. If you do a line by line or comparison of the statutes, and you can find that on page 51 and 50 through 55 of my brief, you will see there is no substantive difference in those statutes. They all remain the same. The prior statutes, Articles 21:16 through 19, and then Article 21:35. They've all been recodified. They've been broken down, perhaps, well, not broken down, perhaps they were broken down into subsections, but substantively the same. And indeed, the amicus who has written about this agrees that there's been no substantive change. So how is it that we get to the point that there's no longer an intent to deceive when the common law has not been abrogated and any of these sections haven't substantively changed? The answer is it hasn't changed, Your Honors, and it hasn't changed because 705-051 is not now, nor has it ever been, nor has the prior statute ever been, the exclusive test and the only element to establish misrepresentation or the misrepresentation remedy through rescission set out in Shelton and in, Mays. It never was that way. It is merely the criteria or principles or minimum principles, at least for a part of those tests that are applied. It remains intact. Annex argument is 705-051 is exclusive. That's it. Whatever in that statute provides the exclusive basis for rescission. But not even the cases they rely on, Lamberos and Parker, say that. And the reason that is because they continue to apply the Mays-Shelton test, but they take out intent to deceive. One of those elements in the Shelton Mays test is reliance. Reliance. You will not find the element of reliance in 705-051, period. It is not there. And in fact, Parker in footnote 10 notes that reliance is not an element in 705-051. So how is it that 705-051 could be the exclusive basis or ground for rescission of a life insurance policy? And the answer is not. It was never intended that way. It was simply some minimum standards about some part of material misrepresentations. And in fact, chapter 705 is entitled about, and always has been, protection of consumer interests. In fact, they note that in the Shelton opinion under the prior statutes prior to recodification. But these Lamberos and Parker, as erroneous as they are, continue to apply the common law test and continue to use reliance in that, even though reliance is not mentioned in 705-051. Here are the flaws in basically the argument that Annex makes, and in their summary judgment, by putting all their eggs in the basket in 705 and not dealing with the common law test, which has always been the test. And the Supreme Court instituted that test. Well, it's 100 years worth of law. And this is why they're predictably silent, Annex particularly silent, on talking about the fact that the law doesn't change. If the law doesn't change, then there is no reason that the common law test would not apply. Why is that? Well, the status of the law at the time of recodification was the existence of Mays, Shelton, and other cases that applied the five-part test. What happened in recodification, and particularly 705-051, was no change. What Annex argues is, because of the existence of the common law application of Mays and Shelton, when they recodified, in order to make sure or order to adopt that decision or the common law, that must have been adopted in 705-051 or some other statute. And clearly that is not the case, because 705-051 has never been, nor its predecessor have ever been, the exclusive test for rescission, the remedy of rescission. So they rely on Fleming Foods. The problem with the reliance on Fleming Foods is number one, in Fleming Foods, they used the term, there had been a substantial change in verbiage between the old statute and the new statute. And with the new language, that substantial change, the plain language, you just couldn't get around it, that there had been a change made, even though the legislature had intended, or so they said, only to recodify and not to change. But they had effectuated a change. Fleming Foods doesn't apply here because there has been no substantial verbiage change. In fact, there's been no substantial change at all since from the old to the new. And as to the second part, the plain language, that only comes into play if there had been a substantial change. The amicus and Annex both talk about, well, the plain language says, well, first of all, that's read in isolation. And second of all, 705-051, again, has never been the exclusive basis and the sole basis or the sole elements for a rescission remedy in the state of Texas. The intent to deceive element has been ingrained as an element to prove rescission for 100 years or more. Medicus versus Todd says that. It goes way back. And if you look at the history of the statutes, you'll find that intent to deceive, at least to the prior statutes of 2118 or 2118, never included intent to deceive. And recodification was never intended to change anything, and in 2005, and it didn't change anything. It merely changed the wording is the same, and in fact, you might argue it's almost exact, and they recodified and put it in some different numbers. There is no change at all. So what they are saying is this: because of the common law, you must ingrain that in 705-051 when it was recodified. But that's not true, because the legislature knew when they recodified about Shelton and Mays and the 5-part test. If they wanted to make 705-051 or any other statute or set out an exclusive statutory remedy, they could have done that real easily, very, very easily. And we point that out. They didn't do it. They did not do it. And Medicus versus Todd deals with this in great detail. And details in the fact that the statutes that we're talking about never included intent to deceive as to regarding a policy during the contestability period. Now, here's where they attempt to compare apples and oranges. They tried to use several statutes that do include language of intentional misrepresentation or intentional conduct. In particular, 705-104, where it talks about, well, for a policy past the contestability period, you can obtain the remedy of rescission if you can show that it was material fact and the misrepresentation was intentionally made. And because that is included in 705-104 and not in 705-051, the court must conclude that the intent to deceive element is no longer required. The fallacy of that argument is 705-104 is substantially the same, if not exactly, as 2135, the prior statute, which had the same language. And that was dealt with, at least in principle, if not in practicality, in Shelton. And in other cases that say that simply because you're comparing apples and oranges, and you're talking about during the contestability period versus after the contestability period, you're talking about the Shelton Mays test versus the statute, which are in some ways the minimum statutes. So apples and orange, 705-104 has nothing to do with 705-051. Those policies, the 705-051 deal with the contestability period. 705-104 has to deal with after the contestability period. So there was never an ingrained requirement of intent to deceive in the prior statutes or in the recodified version. So nothing's changed. There is no difference from the old to the new. There is no difference from the prior test to what it is now. Medicus versus Todd deals with this. This is the only state case that has dealt with this issue. Well, actually, there's some federal cases have, but I want to eliminate those for the moment, that have held that the Mays test in all 5 parts continues to apply when you seek to set aside a policy based on misrepresentation. It is not just 705-051, but that is the sense law. Now we've got these 2 federal cases, and out there, and they're waving them around, setting aside the fact that, thank goodness for the 10th Amendment, that that federal courts typically defer to state courts on the interpretation of the law. Neither one of these courts applied federal standards for interpreting a state statute. They didn't look at the prior law. They didn't look at the legislative comment. They didn't consider all the facts. They just arbitrarily came to the conclusion, because of intent to deceive wasn't in 705-051, that it couldn't be no longer a part of the common law Mays test, Shelton test. In Parker, the judge there, Judge Hanna, uses the term amendment regarding the recodification. There was no amendment. Amendment means change. There wasn't a change. And if we look again at my brief, pages 51 through 55, you'll see there has been no change. There's been no amendment. Second of all, it is tough to reconcile, at least the Parker court cites it, is that the element of reliance is no part of any statute of 705-051. So where does that come from? Well, that comes from the common law. So why is that element retained and intent to deceive is not? And the answer is you cannot reconcile that, because 705-051 and Article 2118 are substantially, if not identical. So nothing has changed. What those courts do is seem to rely on some federal court cases reaching this conclusion. Parker is also problematic in the sense of Judge Hanna had already determined that there wasn't any policy, so why he went off writing on a misrepresentation, I suppose only he can explain. In Lamberos, they failed to provide any analysis, and in fact, both of them failed to apply the Fleming Foods test of, number one, was there a substantial change? The answer, no. And even if there was a substantial change, can you reconcile it with the old version? Well, the answer to that question is yes, you can reconcile it with the old version. They're virtually the same. So why would the law change? And the only answer they're going to come up with is 705-104 mentions intentional misrepresentations, and 705-051 doesn't. But that's again comparing apples and oranges, and it doesn't make any difference anyway, because Article 2135 and 705-104 are the same. If I've got do I have a minute 50 of the 15 minutes left?
No, a minute and 44.
Of the 15 minutes?
Yes, no, of the
Okay.
20.
Okay, I'll reserve the rest of mine for rebuttal, Your Honor.
Mr. Tyser, I did have one question for you. I'm sorry to wait till
Sure.
the end, but it was a question about your extra contractual claims. The appellee has taken the position that you haven't pled for any damages independent of asking for the policy proceeds. Are you in agreement with the appellee's position on that?
No, I'm not, because that defies Menchaca. That is the old Castaneda test of saying you have to have an independent injury or some independent damages. And the Supreme Court in Menchaca very clearly rejected that point of view and said you have to prove coverage typically in order to get 541 damages, but you don't have to prove separate damages. And that's quite clear in Justice Boyd's opinion. He sets out 5 bases of a way to collect, and that is one of them.
As for your extra contractual claims, though, it still seems like some of them still depend on the existence of coverage.
Oh, I believe that part of them do. The prompt pay, the unfair claims do require coverage. I wholeheartedly agree. The misrepresentations, no, and those were never dealt with in the summary judgment. Have I answered your question, Your Honor?
Yeah, thank you.
Thank you, Your Honor.
Anything further, counsel?
Nothing at this time.
Appellee?
Good morning, Your Honor. May it please the court. Appellant asserts and argues a misrepresentation defense requires proof of intent for all types of insurance policies at all times. But it's impossible to reconcile that argument with the plain language of Chapter 705. Now, the lack of ambiguity within that chapter is key. It is crucial to this court's analysis of the question at hand, which is whether intent must be proven to establish a statutory misrepresentation defense for life insurance policies within 2 years of their issue date. Now, opposing counsel has argued that 705-051 or Chapter 705 may not be the exclusive basis, but in front of this court today on this record, 705-051 was the basis for summary judgment and for moving for summary judgment. Now, appellant argues that on top of that statute, it's okay to take old case law to add an extra element where the legislature did not. That argument contradicts the legislature's clear distinction between when intent must be shown, which is under 705-104, and when it is not required under 705-051. That argument that you can take common law and apply it to a clear and unambiguous statute also ignores binding precedent from the Texas Supreme Court in the Fleming versus Rylander case and in State Farm versus Martinez. Now, Fleming made clear that unambiguous language of a statute will control, and at page 284, stated that specific and unambiguous statutes are the current law and should not be construed by a court to mean something other than what the plain words say. Fleming also made clear that legislative acceptance is not applicable where a statute is unambiguous. Now, to the extent there was any confusion after Fleming issued as to whether old common law could apply to alter clear and unambiguous statutory language after a non-substantive recodification, State Farm versus Martinez came along and cleared up any uncertainty that remained. At 804 of the Martinez opinion, the Texas Supreme Court stated that while we generally presume the legislature accepts judicial interpretations of a statute by reenacting it without substantial change, we do not make that presumption, where in 2 cases, there's either been a substantial change or when it would contradict the statute's plain words. Opposing counsel in opening misstated this test by making that or conjunctive. But if there has been no substantial change in the statute, Martinez makes clear that the common law cannot usurp or supplant statute. So what the Texas Supreme Court did in Martinez was it did a course correction. It course corrected court's application of a common law reasonableness exception to a statutory prompt pay violation. So the prompt pay statute required payment within 30 days. But under this common law exception, you could come in at 32, 37, 38 days. And if that was not unreasonable, then courts would give parties an out and say, well, there's really no prompt pay violation. Martinez recognized that there would be times when the common law rule and the statute would then butt heads, it would conflict. And so because there were times that the statute was made to yield to the common law, Martinez held that that is not appropriate in Texas law. So the rationale.
I've got one question for you on the actual application of the statute, because I'm trying to understand your position on what elements, if any, you say still exist that allow for a rescission under these circumstances. Is there a knowledge requirement that when an insured or an applicant for insurance is filling out the information, that there has to be a knowing misrepresentation, or is the fact that merely an applicant may have forgotten information or may have not understood a question sufficient for serving as a basis for rescission later on?
Thank you, Your Honor. So under the elements that apply are strictly under 705-051, and that does not have a knowledge requirement built into it. I know that opposing counsel was saying that Mays continues to apply even after Fleming and even after Martinez. And I think the distinction there is that the remaining 4 elements of the Mays case, apart from intent, kind of bleed into the 2 elements of 705-051, which is that the misrepresentation was of a material fact that affects the risks assumed. So where there's reliance or where there's some other issue that maybe Mays called reliance, a material fact that affects the risks assumed, reliance is kind of bundled into the facts that would be considered by an insurance company whenever they're issuing a policy.
And here's the reason why I'm asking the question. Frequently on life insurance applications, there's a question, for example, about has a family member ever suffered or been diagnosed or treated for heart disease, cancer, or a number of conditions. If an individual is filling out a life insurance application and they don't know that information, so they answer the question no, and it turns out that the insurance company is able to determine later on that there was had cancer, for example, and that they passed away from cancer, is it your position that the statute should be construed in such a way as to allow the insurance company then to rescind the contract after the fact?
So, Your Honor, the distinction, this knowing distinction that your question's getting to, comes into the rationale between dividing 705-051 and 705-104, which is incontestability. So in Texas, you can have an incontestable policy once it's been enforced for 2 years and premium has been paid. Now, the premium being paid is important because, policy can lapse and then it won't be enforced anymore if premium's not paid. But under 705-051, there is no knowing or knowledge requirement. And in fact, even the Mays case, because I know that opposing counsel has argued that the very statement of misrepresentation in and of itself includes the word intent or includes an intent component. Even the Mays case disregarded that, because in the Mays case, way back in the day, the Texas Supreme Court said that a misrepresentation occurs if a statement is made in an application that is false. And so the legislature, when it codified and recodified 705-051, did not include a knowledge component because there is no knowledge component in those first 2 years of policy issuance. All that matters is that the insurance company was provided inaccurate or false information on its policy and then issued the policy. I hope that answers your question. Going back to State Farm versus Martinez. In the Texas Supreme Court in State Farm versus Martinez gave its reasoning or its rationale for holding that a common law exception for reasonableness is no longer applicable after recodification because first and foremost, the statute itself does not provide the reasonableness exception. So to here, 705-051 doesn't require intent. It doesn't require knowledge. And under Martinez, unambiguous statutes cannot yield to the common law. Now, there have been two courts that have directly addressed the issue that's before the court today, and that's the Colonial Penn versus Parker case and the Landeros case. They both came to the conclusion that Section 705051 does not require proof of intent. So what we have at this point is Fleming. We have Martinez. We have opinions that have issued from this court, like the Kirby opinion that recently issued in March of this year. We have opinions like Texas Tech University Health that issued from this court in 2008. All of these cases come together and congeal and make one clear statement, which is that you consistently return to the mandate that whenever you're determining legislative intent, you must begin with the statute's words. And when those—
your response to the statutory language at the beginning of the insurance code saying that it didn't intend to make a substantive change. Do we have to take that as well according to its plain language?
I think the Texas Supreme Court has explained that, and I believe they addressed it in Fleming, saying that the more specific must control over the more general. And so even though the Legislative Council may be given a directive not to make substantive changes, it's not the Legislative Council that makes the law. The Legislative Council might sit around and try to modernize old statutory text. But when it comes to actually enacting law, that's the legislature's province. And they can absolutely affect a substantive change, even if the language is updated, modernized, but there's no real material difference between the old and the new law. So coming back to statutory construction, we consistently return to the mandate that you must start with the statute's plain language, and when the words are unambiguous, the inquiry ends. Common law cannot come in and add to or subtract from or alter the statute's language. And this meets Fleming's concern that citizens must be able to look with confidence to existing laws as they are written without having to dig into the common law or old prior statutes in order to determine what the law is. Now, again, we know that even if it's a non-substantive change, that does not close the analysis. If it's a non-substantive change, we turn to number two, the element two, which is whether there's the statutory language in and of itself is unambiguous. And we know here that the statutory language all throughout Chapter 7005, but particularly 705051 is unambiguous. And so old law under Martinez, even old common law, cannot contradict the statute's plain words. Now, as discussed by the Texas Supreme Court in Fleming, the act of recodification itself is what effected a substantive change in law. Now, opposing counsel may argue that, well, the legislature was deemed to have known about the Mays test whenever it affected this non-substantive change, so of course it absolutely adopted it. Well, that argument actually cuts against opposing counsel, because what really happened is the Texas Supreme Court then would also be deemed to know Fleming. It would be deemed to know Martinez. And so when the legislature enacts and alters a statute in 2005 in a very clear and unambiguous way and says in one provision that intent is required and in another provision that intent is not required, the legislature was deemed to know that under Fleming and Martinez, courts would not continue to apply or additional elements to the legislature's clear language. Now, under Mays and Shelton, they each dealt with prior statutes. And we know under Fleming that those statutes ceased to exist. So the binding authority for this court at this time is Fleming and Martinez. And Martinez's direction that the legislature has not adopted judicial interpretations when those judicial interpretations contradict plain language. Now, I know that opposing counsel has also stated that Mays has been around for 100 years, or the test for intent has been around for 100 years, but the Texas Supreme Court, even as recently as last year in the Agar Corporation versus Electro case, ended up changing years and years of Texas statutory precedent stating that the civil conspiracy statute of limitations is 2 years. Lots of courts had said, well, no, it's 2 years, it's 2 years. But what the Texas Supreme Court did is said, no, civil conspiracy is a derivative tort. So the statute of limitations for it will be governed by the underlying tort. And so what the court said there is even a long history of mistaken application alone is insufficient to counsel against correcting the error. So under Fleming, again, under Martinez, again, just saying that Mays has been around for 100 years is not enough, and it's not the test. And that was the test that Medicus used. There was no analysis in Medicus of the Fleming opinion or the Martinez, well, obviously not the Martinez opinion, because all Medicus did was say, well, Mays has been around for a long time, so we're just going to go ahead and adopt Mays. And that was incorrect, apart from the fact that Medicus dealt with a different type of insurance and a different statute. With respect to whether or not premium has been duly paid, I did want to make just a couple of very quick points on that and whether 705-005 applies, and we do not believe it does. The summary judgment record, I believe, conclusively establishes that premium was duly paid, even apart from opposing counsel's objections to the Scott Marquis affidavit. But above all, if premium had not been duly paid, in this case, there was only one premium. So the policy would never have taken effect. And the policy's own language in the record, it's at the one supplemental clerk's record, page 39. The policy does not take effect until payment of the first premium shown and delivery. And it goes on to say delivery in good health as stated in the application. And so if premium hasn't been duly paid, there is no policy. And the reason that's important is because Ms. Arce's arguments in this case are completely based on recovery. She attempts to recover under the policy. And so when she does that, she makes certain judicial admissions, including that all conditions precedent have been paid, have been met or occurred. That condition precedent acts as a judicial admission that not only relieves American National from needing to prove that premium was duly paid, it also bars Ms. Arce from disputing the fact that payment of premium is a condition under precedent that's occurred under the policy.
What about with regard to Mr. Ticer's argument a moment ago that there are some extra contractual claims, for example, there's a misrepresentation claim, I believe, and that those do not rely on coverage, that they serve as an independent cause of action or an independent basis for recovery.
Right. Opposing counsel has conflated in the extra contractuals analysis a bona fide dispute under the claims analysis, whether or not there's a reasonable basis for denying the claim, which obviously here there was. And as Judge Byrd decided, there was a reasonable basis. He's conflated that standard with proving intent at a jury trial. And so here, what we have is there was no recovery under the policy because we had a misrepresentation in the application. And under Progressive County Mutual versus Boyd, decided in our brief, if there is no breach of contract and the allegations and the damages only flow from the breach of contract, there is no sustainable extra contractual claim. And here, throughout her pleadings, the only damage alleged is lack of payment under the policy. So there's also been a little bit of discussion by opposing counsel that the claims person must prove intent as a matter of law and no intent as a matter of law at the initial denial letter that goes out to the insured. And I just wanted to point the court to the claims person's testimony about the basis given to the insured. And this is replete, it's in the record, also with the intent, the denial letter that went out. But at second supplemental clerk's record, page 81, Ms. Sajak states she's responding to a question upon about what information she relies upon to know that the right standard applied. And she states that she knew that this applied because of the information she received on the application, plus what she received from the medical record showing that the insured knew he was sick but chose not to provide that information. And that's all that needed to be shown in order to show that there was a reasonable basis for denial of the policy, and therefore no extra contractual claims exist under the policy, or in this case.
Counsel, anything further?
If there are no further questions from the court, then no, Your Honor.
Any questions from the panel?
No.
So, Aldi, thank you very much. Mr. Tasser, you have 5 minutes.
Thank you, Your Honor.
Thank you. Thank you, Your Honor. First thing I want to tackle is the statement made that recodification was a change in law. There was no change in law. The verbiage was the same. The premise of the argument is, as I understand it, by not including intent to deceive in 705-051, then there was a change in law, but there wasn't a change. It's the substantive, what's in the law, not what the common law says. The second flawed premise is 705-051 provides an exclusive basis, as well as its predecessor statute, Article 2118, which was the same substantively. Again, no ambiguity, that it would ingrain an intent to deceive. There's no such requirement in the statute, and neither is 705-051. The only aspect of what you need to prove for rescission in a life insurance policy. I would invite the court.
Mr. Tasser, I may have lost your audio.
Can you hear me now?
Yes, sir.
Okay, sorry. I would direct the court respectfully to our discussion in our brief where we talk about the analogy is that all good students will not get into medical school unless they make good grades. Well, that doesn't mean the word unless in the statute 705-051. That doesn't mean that anybody that makes good grades must get into law school any more than the term unless means those two elements are the exclusive basis for rescission. That's particularly true where you have no substantive change in the law. Counsel spent a lot of time on Martinez. The problem with Martinez, it is a change in law case. And I quote, "We do not make that presumption when there have been substantial changes or when it contradicts the statute's plain words. Here, there have been substantial changes that plainly require an insurer to pay policy proceeds within 60 days to pay penalties too." So Martinez is a change in law case. As to the plain language, again, I would go back to the statement that 705-051 and its predecessor, Article 2118, were never, by plain language, the exclusive basis to determine rescission on a life insurance policy in the state of Texas. Never have, never were. Only federal courts, 2 federal courts have found this after 15 years of recodification, they've suddenly decided, 2 federal courts, hey, intent to deceive wasn't in the recodified statute, and this kind of goes with the premise and the fallacy. Recodification was a change in law, but there wasn't a change in law. You have to take the common law that comes along with the recodification in it, and the recodification in 705-051 didn't change a darn thing, just like Article 2118 didn't have an intent to deceive in that regard. The bad faith I want to get to, and well, actually, I want to deal with something that was asked. about a knowing component about misrepresentation. There's a public policy reason why there's an intent to deceive element and why the legislature has continued to accept the common law rescission remedy set out in Mays and Shelton. There's a reason for that. And that's for how these misrepresentations or code word errors in the application process might be. Somebody doesn't know the answer. The agent might put the wrong information down. In this particular case, Mr. Arce gives a negative health history, and they want you to believe that he only told them about his hypertension, but he didn't tell them about what they say he had about hepatitis. Now, Mr. Arce has about a 7th grade education. He wouldn't know any of that. And what makes it even more suspicious in this case, as the record reflects, is the agent said she didn't let him see all of his answers on the application when they were signed. And in fact, she wasn't sure that the program allowed for that. So that's the kind of thing we're talking about. People that don't speak English, people that may give the wrong information erroneously or misunderstand. Some of the questions that are asked may not be understood. In the summary judgment record, the court would find an example of where I asked the agent some of the questions she asked Mr. Arce and asked her what that meant. And she could not tell me what that meant. There lies the problem, and that's why there's a public policy reason for that. I see my time is out. I would just ask the court for if some informal leave, if I could, to briefly respond to the amicus brief and the Lamberos case that they filed just recently. I'm not talking about pages and pages. I would like a little bit of leave for that, a brief response on that. And let's see. I believe that's it. I really appreciate the time to argue in front of you today.
Counsel, thank you. I didn't see the filing date on that amicus, but let me do this. We'll give you a week from today to file just a letter brief if you want, and the appellee will have 10 days from that date to file any response. And subject to those deadlines, then this matter will be presented to the panel on the briefs and the arguments of counsel. We appreciate you being here today. Appreciate you participating in this new form of oral arguments. I think it may be something that's the new reality, the new normal. It's unusual for us. I'm sure it's unusual for you, but we appreciate it. We hope that it hasn't been distractive. I know that sometimes personally I'm looking at multiple screens here, and it may look like I'm looking off when I'm actually looking at your brief or something that I pulled up that's relevant, and I hope you understand that. And if you have any questions or any comments just about this format, we'd be interested in hearing those. We're always wanting to improve the process any way we can. But we appreciate your presentations today, and subject to the leave of court to file a letter brief, then this matter will be submitted.
Thank you very much.
Thank you, Your Honor.
Thank you, counsel. At this time, we'll be in recess.